Now do this. Take a deep breath in. Another one in and another one. Let it all out. Now do that and keep doing that without actually being visible. So you want to be able to do this without it actually knowing that you're breathing in. So you ask a question. So someone asks you a question. Hey there, Jason, how was your day today? Yeah, it was really good. A really good day today. I did this. It makes you look like you're thinking about the answer. It makes the person you're talking to feel valued as well. So take your time when you're answering the questions. If you need more time, didn't understand the question, ask them to reword it for you. It's perfectly fine. Say sorry. I repeat the question. I didn't understand your question. This is much better than guessing or blurting out some random nonsense. Mind you, saying that, pausing does show you're thoughtful, that's for sure. Not that you're evasive. Answer only what's asked, briefly and directly. This is crucial. Keep your answers short and on point. Cross-examination is not your turn to tell your life story or unload your grievances. If you're talking for longer than 10 seconds, you're talking too much. If the question can't be answered with yes or no, do just that. Say, so many litigants in person fall into this trap of thinking this is my chance to make the judge see what the truth is and understand my point of view. It isn't. Trust me, it is not. That is what your main testimony or statements are there for. When you're being cross-examined, giving long-winded explanations or volunteering extra information will only backfire, and it usually will hurt you, that's for sure. Why is that? Two reasons. Judges are impatient. They have limited time and will get frustrated if you wander off track. Frustrating the person who will be deciding your case is not probably the best strategy. Number two, smart opposing lawyer will let you ramble because they know what you might say. They know that you might say something that's going to be inconsistent or revealing that they can then later use against you. That's what they're doing. They think if you waffle, if you let it go on and on, you'll dig yourself at your own grave, and they are often right. Don't take the bait. If a question needs a lot of an explanation beyond yes or no, keep it to one or two sentences. And then stop. Like I say, anything longer than 10 seconds is too long. They'll ask if they want more information from you, then let them give you, and then let them ask for more information. Don't fall into the trap. Yes or no, and sometimes a lawyer will insist you answer yes or no, or to a question that is oversimplified or misleading. This is a trick. Judges often do expect you to answer the questions asked. Here's how to handle it if the question is basically, have you stopped doing X bad things? The classic loaded question. You can respond calmly. I'm sorry, I don't answer that with simple yes or no because the premise isn't accurate. May I clarify? If the judge allows, briefly clarify the truth. If you're cut off, you might just have to stick to your position and say, no, that did not happen. Or no, that characterization is not correct, which at least flags your disagreement. The key is to not be evasive, but also not be trapped into agreeing something false. This is a tightrope, so practice how to deliver a firm, polite answer under pressure. Stay truthful. Admit what you must do. I'll be blunt. If you lie or try to bluff your way through, a skilled cross-examiner will nail you to the floor. Yeah, and your entire case will crumble. Because once you are seen as not credible, nothing's credible. You lie, you're not credible. Nothing you say will be trusted. So there is a tough fact that you have to admit if you're wrong. Maybe you did shout, maybe one argument, and maybe you did miss a child handover once. Own it with humility. Yes, I did raise my voice during that incident, and I did, and I regret it. I've since been taking steps to manage my stress better. A candid admission diffuses the attack. It shows you're honest about your flaws, which actually boosts credibility. And in contrast with the denial that can be disproved, that could lead to you being seen as a liar or even a big risk perjury. Remember, credibility in family court is everything. If the judge sees you as generally truthful, they'll forgive minor mistakes. If they catch you in a significant lie, you're done. That you are done. You need to know your own evidence cold. Yeah, before you even step foot into the witness box, study your own statements and evidence like your life depended on it. Because someone on the other side certainly has. They will often cross-examine you by referencing what you said in your witness statements or affidavit. In your statement, paragraph 14, you said X, but just now you said Y. Which is true? If you don't remember what you wrote, you're in trouble. Consistencies between your oral testimony and written evidence will make you look unreliable. So review all of your earlier statements and even text messages, emails, anything related to the case. If there is a small error, in your statement, you can clarify them at the start of your testimony. Some judges let witnesses correct mistakes up front, and it's better that you do acknowledge a mistake, a typo, date mix-up, wherever you might be, then have a barrister pounce on it and make you look like a deceptive person. Don't forget, their job is to turn your fact into fiction. The silent secret here is lawyers bank on you being poorly prepared. They love catching a litigant person off guard with their own words. Don't give them that satisfaction. If you know your material, you can calmly say, what I meant there was X, or let me clarify the date. Might have been wrong in my statement. But the fact of the matter is, the exact event did happen. You stay in control of your narrative, emotional control, and equals case control. Cross-examination can get intensely personal. You might get accused of terrible things in questions. They might read a private text of yours in mocking tone. It can be infuriating or humiliating. But here's your mantra. Do not react, at least not with anger or outbursts. Inside, you can be thinking this is outrageous, but outside, you're the picture of calm. If you need to take a sip of water or deep breath to center yourself, do it, because the moment you snap back, how dare you say that, or an emotional rant, you've stepped right into their trap. Instead, respond to nasty questions with factual answers or a simple, calm denial. Example, opposing counsel sneers, you enjoy harassing your ex, don't you? It's all a game to you, isn't it? A reactive person yells, that's a lie. A master of being cross-examined, that's going to be you, calmly says, no, absolutely. Do not. I'm here to ensure I can see my child, not play games of short controlled, and you've denied, and the characterization without losing your own cool. You come off as reasonable and the lawyer as a bit of a jerk for even suggesting it in the first place. That's a win for you. The judge has eyes everywhere. The judge play to the judge, yeah, not the lawyer. Remember, while the lawyer is the one asking your real audience is the judge or magistrates, whichever. When you answer, it's often helpful to speak to the judge, make eye contact to the judge with them, not the hostile lawyer, especially if explaining something technical. You want to look into their eyes, show the judge that you're sincere and unafraid of scrutiny. It also psychologically takes the power away from the questioner. You're saying, I know who ultimately matters here. Just be careful to do this naturally, not in an overly theatrical way. By mastering these techniques, you transform cross-examination from a dreaded ordeal into a showcase of your credibility. Think of each touch question as an opportunity to prove how solid and calm you are. If the other side throws curveballs, you sidestep it with poise. If they try to bully, you remain unshaken, which often makes the bully look bad. This drives professionals crazy. By the way, absolutely mental. An LIP who doesn't take the bait because it neutralizes one of their biggest advantages, your fear and inexperience. Minds, what not to say. Avoid these common mistakes. Now that you know the do's, let me hit the don'ts, the factual mistakes that can undermine your hard work. Consider these as landmines scattered across the examination field. Step on one and boom, your credibility is blown way out. We're going to identify some of them now so you can walk around them safely. Don't turn into a pit bull. This applies when you're the one asking questions. Do not get aggressive or argumentative with the witness. Yes, you might be furious at your ex's lies, but cross-examine them is not the time to vent anger. If you raise your voice, use a harsh tone, or badger the witness, you will look like the aggressor and the antagonist in the story. The judge will immediately think you're more interested in fighting with your ex then focusing on the child. Remember, aggression equals instability in the family courts. In the eyes of the family court, definitely. Keep your voice measured, your demeanor calm and businesslike. Every question should come off as reasonable. If the witness is evading you, you can press firmly, but never with insults or shouting. Don't make the personal attacks or accusations. Calling the witness a liar or making snide comments is a huge no-no. Not only will it anger the judge, but it gives the other side moral bias and the moral high ground. Attack the facts, not the person. For instance, instead of she's completely lying about that, ask a question that demonstrates the lie. If you're being cross-examined and the lawyer is goading you by attacking you, and don't take the bait. Don't take the bait and attack back. Stick to the answer in the questions. Personal score settling can wait for another day, preferably never in court. Don't ramble or volunteer extra information, whether you're asking or answering. Avoid wordiness. Avoid it. If you're cross-examining, don't preface your questions with a mini speech. Just ask it. If you're answering, don't start telling a story unpromoted. Long, rambling discourse hurts you. If either puts everyone to sleep, frustrates the judge, or opens the doors to opposing side to pounce on. Inconsistencies. One question, one answer. No unsolicited tangents. Don't dodge questions. You must answer. If you're being asked something that you don't want to answer, there's legitimate, answer it. Trying to evade the fair question makes you look shifty, and the lawyer will just pin you to the floor. If you truly don't know or recall, it's okay to say, I don't recall, I don't know, I'm not sure. But if you clearly should know, where were you living in 2021? Don't pretend ignorance, answer directly, then stop. And remember, a pattern of non-answers will irritate the judge and prolong the pain for you. Don't argue with the judge or opposing counsel. This sounds obvious, but in the heat of the moment, many litigants in person fall into this trap. If the judge tells you to move on, move on. If the judge sustains the other lawyer's objection to your question, don't argue, but I'm just trying to save it. Arguing with the judge is practically suicidal for your case and for you. And if the opposing lawyer is being snide, don't snipe back at them. You can politely assert yourself if needed. Counsel, please let me finish my answer. If they keep cutting you off, then never be combative in tone. Keep it professional. Always keep it professional. Don't interrupt. Let the other person finish what they're saying, and then whether it's the witness answering the questions or the lawyer questioning, cutting someone off in family court or in any court is even if they're spewing nonsense, makes you look out of control. If you're the witness and the lawyer is badgering you without letting you answer properly, look to the judge for help. The judge should intervene. If not, you might say, I'd like to finish my answer, but do not get into a shouting match of interruptions. That chaos only makes you both look bad. And guess who the judge is more likely to blame? Let me think. The self-represented person, unfortunately. Don't forget to prepare. Winging it is a mistake. Going into cross-examination without being prepared, without prepared questions, or without having rehearsed tough questions you might face is like going into a boxing ring with your hands down, and you will get knocked out straight easy. Preparation is your friend. It gives you confidence and a game plan. So you're not reacting on the pure adrenaline. Use the tools and techniques we've been discussing and covered. Write down your key questions in advance. Practice answering our awkward questions calmly. Maybe have a friend grill you or use an AI tool. We've got someone on MackenzieFriendNearMe.uk. Get them there. The more you practice, the less likely you are to freeze or ramble when it counts.